It's been a day.
It certainly has, as usual, right?
Always
Yes.
solving the problems of the world, one estate plan at a time.
Hi, I'm Joycelyn Urech of Urech Law, and I practice in the areas of probate, estate planning, and real estate. Mostly estate planning, and the other two just kind of get dragged along.
And I'm Angelique, I'm her paralegal, and I'm happy to be here.
And I'm happy she's here as well. It's tea time every afternoon. We like to have a cup of tea.
And we're gonna spill it.
Exactly.
We have our tea, and we're gonna talk about the tea.
Yeah, what's the tea on
What's the
estate
tea you
planning?
need to know?
What's the tea on estate planning? Yay!
So, what is estate planning?
Estate planning is when you put together documents that explain exactly what you want to happen when you die, not if you die, everyone's going to die. Whether it's suddenly or you have a long illness or whatever, then you wind up putting together documents that say exactly where you want your precious items to go, your assets, or whatever it is that you have, and that it goes to the people that you want to have it when you die.
So who needs an estate plan anyway?
Everybody needs one. I'll give you 3 examples. Like a single person, we've seen this. A single person dies, no parents,
No siblings,
no siblings,
no child,
no child, no
spouse,
no spouse, no first cousins. And so then you have to go searching through their family history to try to find heirs. And these people may not even know the deceased person. And it could be difficult to even try to get them on board and understand what the process is or that they need to be involved.
Then we sound like scammers.
Exactly, right? Exactly. We could sound like scammers.
So, everybody needs an estate plan. But, I mean, ChatGPT and Claude AI and all of those generative AI softwares, they can do that, right? Why do they need an attorney?
Well, you know what? You can even go to a free website and get one. But I've seen what they generate, and okay, so Claude AI and ChatGPT do something that's called hallucinating. So if it doesn't know exactly what to do or how to word something, it's going to make something up. and then I get this person died, and they come in with these wills, and I'm looking at it and thinking, what in the world is this? And how do I take care of this? And is it signed properly? Do you even know how to sign it properly? And does it actually do what it is that you think it's doing? Because there could be terminology and things that are entered in there, and you don't even know what it means. There are terms of art for
Terms of art.
that are very specific. Yeah.
And so, just let's give the people a ballpark of the price difference
The price
of
difference, okay.
planning on the front end with estate plans
Okay, so.
and the back end of if you have nothing, you have to probate.
Well, it's like anything else. If you plan, then you have built-in control. And so you get to control basically how much you want and what you want it to do. And the price for the planning is appropriate to what you have decided you want. On the back end, you lose control over that because the state is telling you exactly what you have to do. When you have to go through all these steps, there's an attorney ad litem that's appointed. Perhaps in your situation, they have to figure out, they have to pay them, and they have your other attorney, and everybody gets paid. And so it gets quite expensive, and so the difference could be, it could be $10,000 or $20,000 for a person who died without a plan. For a person who dies with the plan, it can be far less. It can be a quarter of that, just depending on what they choose. They want a will, they want to trust us a little more, whatever. It depends on your situation.
About these clients that we see that they come in and they've got a will from like 2003. What happens to them? That's good, right?
They are good. They're still in effect. However, 2003 is not 2026. So 23 years, let's see what could have happened in that time, right?
Got married, got divorced, had a baby, had grandchildren, got a new house, sold an old house.
New husband or wife, exactly. So you have a blended family and a whole lot of things are going on. And so you look at that document, and it usually doesn't quite fit your life at that point.
No.
Yes, whatever it says is what gets done, and it's not always what the person would have wanted because they didn't do anything. They had it prepared and they put it away, and they don't want to think about it anymore.
So estate planning is not just one and done.
Oh no. Okay, so anytime anyone comes into our office, they are entered into our system. And once we finish with the plan first, every 3 years we check back to see, did we add assets? Did anything change in our life? Do we need to update anything? And the reason we do that is because when they die, we want to make sure that their wishes for what they wanted when they die are actually what they get and what the family gets. And so the family's taken care of. We want to make sure that what they planned is what they get. Oh, okay.
All right, so what about these horror stories that we see all the time of, well, actually, so we get clients that call and they're like, I just need something really simple. And you know what, when we get clients that say they need it really simple, it usually means it's really complicated.
Oftentimes it is because, okay, so what happens is they come in and they think they need simple. And then we talk about the family dynamics and what it is they actually want to have happen. And it's not complicated, but it's just more than they were expecting. So we give them a choice. We can do simple, and if simple's gonna work for you, then that's what we'll do.
So what are some of the circumstances that people need to consider when thinking about their estate planning?
Okay, so single people have the hardest time because they don't have the natural people that you would say, okay, it goes to my spouse, or it goes to my children, it goes to my whatever, you know. Then they have to think outside the box. And I've had some thoughtful people who come in and they're like, they have their friends list. They give to their friends, you know. It's like, I want to be one of those. and then maybe siblings. They may have some siblings, and but they have to really think it through because sometimes it's charity. You know, it could be charity or whatever.
I think a lot of people don't realize that they can donate to charity in their estate.
Exactly.
And then it's not going to the state.
Exactly. That's the whole point, is to keep it from going to the state. You want it to stay, to do things that you want done or people you want to care for. And so it's very important that it's worded just right for those things to happen. And you have contingencies in case those people that you left it to are gone. And then another circumstance that people don't consider is those blended families are really special. People come in and say, everybody gets along so well, and we're just going to do it this way. And I tell them this.
Famous last words.
Once one parent dies, you have children on both sides. The children of the deceased person a lot of times will feel like, oh my gosh, I'm not going to inherit from my parent. And they can become very angry, very stubborn, and they become someone different. They're grieving. And so when people are grieving, they become someone different than what you would expect normally. So those are some things to consider. And that happens in families that aren't blended as well.
Absolutely.
Sometimes there's a sibling that maybe felt left out, and maybe they were the middle child, and they felt like they never got it. You know, so exactly, they just don't have any idea. And so it's really important that we get, and I try to get people to tell me about your family. I want to hear about your family, because if I hear about your family, then I can help you. Like, okay, so this is what the dynamic is. So let's not make that one child that the other two don't get along with the trustee of a trust. That's not a good idea, you know? And so I can help them with that, and I can point those things out. But if they insist on it, that's what I'm going to do, because the client has the last word on the way things get.
So what are some other things that we consider when drafting an estate plan, but also that the viewers at home can consider when looking for an attorney?
Okay, so they need to find somebody who will sit down with them and listen to what it is that they want. They will sit down and explain what it is that you have to offer them, and then let them choose the path they want to take to get the results they're looking for. So that's what I try to do. I spend a lot of time with that. And we also spend a lot of time asking questions. We understand what your values are, so that when I'm drafting, if I have a question, I can usually flip to that and say, okay, this is what they would prefer, rather than, you know, A than B or C or whatever.
Yeah.
And if I have a question, then I would call them. And also somebody who takes time to review it with you, somebody who explains it to you, and who's available if you have questions even afterwards. And so I think that's really important, and that's what we do try to do. And we also, besides following up, every 3 years we're going to come back and circle back and say, hey, do you need anything? So I think those things are important, and that's why I do it the way I do it.
You look at the whole person, the whole family, the whole package. You're not just a number or a document.
Exactly. I'm not just cranking out documents. And I just like filling in the blank and changing the names. Everyone's different. Every single one is custom. Every person comes in, theirs is exactly what they need for their family. Probate can be difficult, and that's one reason why a lot of people try to avoid it. And I wouldn't call them horror stories, except that I have had some where I'm not even sure. I get into it, and then I'm not even sure exactly how we're going to finish this. How are we going to proceed with this? Where you have a person who supposedly had a will, but nobody can find it, or the person who had it won't give it to us,
the one-page will that said everybody who doesn't predecease me gets my stuff.
Exactly. If this person dies, then the people who receive it like those who are not predeceased. Which would be
everybody.
And okay, so that story is the person who apparently went to Office Max or one of those places, office supply place, and they have forms. They got the form book, tore the pages out, wrote in, filled in the blanks, wrote in the names.
They tore the pages.
And the whatever. And so the question for the court was, oh my gosh, is this a handwritten will or is it a formal one? So we tried to probate as a formal, but it was not considered formal because there was handwriting on it. So then you have to find witnesses for handwriting, even though this person tried to make it so that it would be easy for the executor, but it didn't make it easy. It made it more difficult. But we have to go look for witnesses to say, yes, that's his handwriting, and yes, he was competent at the time, so you have to find people to testify.
So there's differences between a formal will and a handwritten will.
Oh, absolutely. Yes, a handwritten will requires witnesses for the handwriting and yes, testimony. They have to go and testify. And then you have to figure out who is going to be appointed, because they don't oftentimes handwritten when they don't say, I want this person to be my executor, because they don't ever say that. They just said, this is my will, then I want my things to go.
I leave my shoe collection to Billy.
Exactly, right, exactly.
Not anything that just says, I leave my stuff counts as a will. So
yes, it does. Oh, it does. That's crazy. Okay, so you can have you can write it on a napkin.
But you have to sign it.
You have to sign it and date it.
What are the requirements for something to count as a valid will in Texas?
Okay, a handwritten one. A handwritten is called holographic, and it has to be dated and signed and have testamentary intent, meaning you have given, I'm giving my car to Billy Bob. And you don't have to say when I die. You just have, it looks like that's what you are intending. It's like, and you start listing, I give my car to Bob, I give this to that person and this. Obviously the person's leaving. I leave this to this person. So it's the wording, and the judge actually honestly gets to decide whether or not it has the required testamentary intent. So there could be some questions. It's not the best way. If you're going to do that, I mean, I've seen people who were on their deathbed and like, I'm so desperate, I'm going to do this, and they put, this is my will, this is my last will and testament, and then they will write down what they want. They sign it and date it, and sometimes notarize it. And those are better than nothing. They're better than nothing, but it's not the best.
Yeah, you still have to probate it anyway.
You have to probate it, and it's expensive because then you have to prove up the handwriting, and so you have to have 2 witnesses and all of that. So you have to have that. A formal will is the best way, and I know people like to save money, but are you actually saving money? An intestate probate is going to cost at least $10,000, you know. And so when people come in and they're like, "Well, that's expensive," no, it's not. And you get to pay for it. You are the one who's paying for it. Your estate will pay for whatever proceedings happen.
I think a lot of people don't realize that, because I feel a lot of people are of the mind, well, I'll let my kids handle that when I die. But it comes out of your estate still.
Yes, it does.
It's still you paying for it.
And what makes it even worse is that your family members may have to pay out of their pocket first before they can get to your money to reimburse themselves. But they can reimburse first because it's for your estate, not theirs. And then when you file probate, the creditors have to be notified, and creditors, there are companies that do nothing but scan the probate records looking for people who owe money to credit card companies. Yes, exactly. And they will send a letter, when they find out there is a probate, they send it to the attorney and say, hey,
oh yeah,
this person owes, we've got money. It's like, okay, put it in the file. If we find some money, maybe we'll pay you.
We have too much fun here.
We get to help people, we get to assist them now and in the future, and it's great.
You know what else we need to talk about is our upcoming event.
Oh, June 16th, we're gonna have an event that's called Tacos and Trust, and we're gonna talk all about estate planning and trust, and we're gonna have a good time. It's gonna be 7:30 in the morning, so it'll be before work, hopefully for some of you, and you're welcome to attend. You just need to go to our website and
There's a landing page.
Yes.
For the educational events.
right,
And you can sign up right there.
right. You just click on that and sign up on Eventbrite so we know you're coming.
What a lot of people don't realize too, speaking of trusts, is that there's trends in the practice of law. And recently it has become out of trend for attorneys to do wills for people.
Well, we do a will, but trusts have become more trendy, and you always have a will when you have a trust, but you don't always have a trust when you have a will. So, and there are reasons for that that we can explain.
And we'll talk all about that at our event on June 16th.
Right.
And that's the tea.